All right, so let's go ahead and get started and finish up Gratz for Bollinger. I want you to remember that this is the undergraduate version of Grutter v. Bollinger, which dealt with the University of Michigan Law School. This deals with undergraduate admissions at the University of Michigan more generally. The previous case, Grutter versus Bollinger, was a 5-4 decision with Justice O'Connor writing the opinion. This case is a 6-3 decision with Chief Justice Rehnquist writing the opinion. To give you a little bit of context about what was going on in the background, the University of Michigan undergraduate admissions considered a number of factors when making these admissions decisions, including high school grades, standardized tests, quality of the high school curriculum, strength, geography, alumni relationships, and leadership. But they did all of this in a quantified fashion. So they had a point system. The point system was 150 maximum points and 100 points guaranteed admission. Anyone who got over 100 points was automatically admitted, but individuals who scored under 100 could still be admitted. So the scale looked like this. Anything that was 100 or plus was admit. 95 to 99 was admit or postpone. 90 to 94 was postpone or admit. 75 to 89 was delay or postpone, and 74 and below was delay or reject. So they also, among that list of factors that they considered, also considered race with regards to admissions, very much like the Grutter case, although they did it in a very distinct way. African Americans, Hispanics, and Native Americans were considered underrepresented minorities, and virtually every qualified applicant from these groups had been admitted over the years. And the reason for that was membership in an underrepresented racial ethnic minority was worth 20 points. So if you need 100 points to be guaranteed admission, a fifth of that point scale was automatically given to individuals who are racial or ethnic minorities. So two white women, both were denied admission. One was very well qualified and the other was qualified, but both were, quote, less competitive than students who had been admitted on the first review. They ended up suing and claiming that the University of Michigan's policy violated the 14th Amendment's Equal Protection Clause and also Title VI of the Civil Rights Act of 1964. University of Michigan claimed that its policy was consistent with Justice Powell's decision in Bakke, but ultimately, with Chief Justice Rehnquist writing the opinion, they rule against the University of Michigan in this case. With regard to the equal protection claim, just like in Grutter v. Bollinger, the court recognizes that diversity is absolutely a compelling interest under the strict scrutiny test. But the university's policy does not survive strict scrutiny analysis. So not that first prong of the test, but the second prong of the test about narrowly tailored means, this case fails at that level. Rehnquist writes, to withstand our strict scrutiny analysis, University of Michigan must demonstrate that its use of race in its current admissions program employs narrowly tailored measures that further the compelling governmental interest. However, University of Michigan's policy, which automatically distributes points, or 1/5 of the points to guarantee admission to every single underrepresented minority solely on the basis of race, is not narrowly tailored to achieve the interest in educational diversity that respondents claim justifies their program. In essence, they ruled two very similar ways that Justice Powell did in the Bakke case, in which he argued that any sort of quota-based system was simply run afoul of the 14th Amendment's Equal Protection Clause. Here, they say their argument is that any sort of plus that actually is quantified in a way and gives points solely on the basis of race is going to run afoul of the 14th Amendment's Equal Protection Clause in this case. Their use of race admissions was not narrowly tailored. It was simply, it granted a significant benefit to racial minorities that was not available to everyone else that was applying. You need to juxtapose this with what was going on in the Grutter case. In the law school admissions case, race was considered as simply another factor in a holistic review of the applicants. The undergraduate admissions at University of Michigan was not a holistic review, it was a points-based review. And because individuals who were from underrepresented ethnic and racial minorities received automatically 20 points that was simply not available to individuals who were not underrepresented minorities, really runs afoul of the 14th Amendment, at least according to the court. So they definitely identify that race is still a compelling interest for states and for colleges who wish to increase racial diversity within their classrooms. But the method by which they did so could not survive strict scrutiny analysis. Taking the two cases together, Grutter and Gratz, what Justice O'Connor's legacy here is, even though Justice O'Connor didn't write the opinion in Gratz, she does very much shape what affirmative action policy looks like between the two cases, her being in the majority of both of them. She functionally writes Justice Powell's legacy into this case. Remember that Bakke was not a binding decision, it was simply a judgment of the court. Well, 15 years after the court, after Powell is retired and 5 years after his death, his opinion from Bakke pretty much gets written directly into law in Grutter and Gratz. And so going forward, this tends to be the operating manual for states and for colleges who wish to use affirmative action in terms of admissions. That in part of a holistic review, race can absolutely be considered in terms of admissions, but individuals who are from a racial or ethnic minority cannot automatically be put above individuals who are not on the basis of some quantified factor.